3 months, Morris, 181F3D at 671. Finding violation when child was placed in foster care for 3 years and cut off from all contact with her father during that time. Although the state's taking children for any amount of time is a serious encroachment on a parent's fundamental right, the one-day removal of Romeo's children is a much less substantial interference with the right to control a child's upbringing than these far lengthier removals. See Hardor Whiskey. 844F2D at 1217, finding that the temporary nature of a removal was, quote, alone sufficient to prevent us from concluding that the appellant's conduct violated clearly established law, unquote. Combined with the rule of a child welfare officer who had a pending investigation into domestic violence, and there is not a similar case finding substantial due process liability as a result, qualified immunity protects Brown from the substantive due process claim. Part B. The Due Process Clause does not just provide parents with substantive protection from interference with their liberty interests in the care, custody, and management of their children. It also requires that the state follow certain procedures before encroaching on those parental rights. Tosky versus Kramer, or Kramer, 455 U.S. 745, 753 254, 1982. Stanley versus Illinois, 405 U.S. 645, 658, 1972. Gates versus Texas Department of Protective and Regulatory Services, 537 F3D 404, 435. Fifth Circuit, 2008. And importantly, for the qualified immunity analysis, unlike the fuzzy continuum that governs substantive due process in this area, there are bright lines when it comes to the procedural safeguards. The rule is this: a child cannot be removed, quote, without a court order or exigent circumstances, unquote. Gates, 537 F3D at 434. This is the same standard that governs a child's Fourth Amendment claim for being removed from the family. Abid at 345. Gates followed other circuits that had, quote, equated the procedures required under the Fourth Amendment with those required under the 14th Amendment. Under the Fourth Amendment, for searches and seizures related to child abuse investigations, albeit at 435, citing Doe versus Kearney, Kearney, 329 F3D 1286, 11th Circuit, 2003. Wallace versus Spencer, 202 F3D 1126, Ninth Circuit, 2000. Tenenbaum versus Williams, 193 F3D 581, Second Circuit, 1999. With Gates on the books, we later held that a procedural due process claim overcame qualified immunity at the summary judgment stage because evidence would allow a jury to find that children were seized without court approval, or an emergency. Wernicke versus Garcia, 591 F3D 386, 391, Note 7, 5th Circuit, 2009. Footnote 1. Brown contends that Wernicke's decision not to, quote, conduct a separate analysis of the Wernicke's Fourth Amendment claims, unquote, means that it was rejecting the possibility of the parent's procedural due process claim. That ignores what the court did in the remanded. It remanded to allow the due process claim, just like the children's Fourth Amendment claim, to continue past the summary judgment stage. 591 F3D at 391 Note 7. There was no need to conduct a separate due process analysis because under Gates the standard was the same as that governing the Fourth Amendment claim, albeit it is thus clearly established that a court order or exigency is the pre-deprivation process that is due when social workers remove a child. Footnote 2. When an exigency is the basis for the removal, a prompt post deprivation hearing is required. Gates 537 F3D at 435, finding that no due process violation because exigent circumstances supported the removal of the child, and a hearing was held the day after the seizure. Martin versus Texas Department of Protective and Regulatory Services, 405 F Supplement 2D 775, 790, Southern District, Texas, 2005, finding no procedural due process violation because the child was removed based on allegation of sexual abuse and parents received a hearing within 24 hours. The complaint alleges that neither a court order nor exigent circumstances existed when Brown seized plaintiff's 7 children. It is undisputed that Brown did not obtain a court order, nor was there reason to believe that the children were in imminent danger of physical or sexual abuse if they were not immediately removed. Gates. Cruz had been accused only of spousal abuse, had left the apartment weeks earlier, and there were no reports that he had attempted to return. Indeed, defendants do not even try to argue that there was an emergency related to the child's safety. So, world, as you can see, this case is from the United States Court of Appeals. The case number is 18-20157. This is document number 00515097312, page 8. Date file August 29, 2019. Still, the Fifth Circuit has been holding on to our case. Our case was filed like in May There have been some procedural issues, but there's now no need for any delay. There's no longer any need for delay. The rule is this: a child cannot be removed without a court order or exigent circumstances. In our case, we got no pre-deprivation nor post-deprivation hearing. We got no what they call a final permanency hearing before final order. The very fact that there was neither a pre-deprivation hearing nor a post-deprivation hearing renders the entire proceedings void and criminal in nature, meaning all these people committed crimes. All these people committed crimes. I don't have to argue before anyone, any lawyer, privately and publicly, will tell you that what was done to us were crimes. They come after me for a number of reasons, but as you can see, as it can concern you, the lesson for you to learn, you will not stand up for your rights. Because if you do, we'll do this to you. We'll do this to you. Don't stand up for your rights. Don't challenge us. We do what we want to do. Do you understand? If we come after you, if we want your child, give that child to us. Because if we don't kill you, murder you, you might just wish that we will have. What's the name of this case? The videos are clear. The Fifth Circuit, all the judges on the court, and I do mean every last one of them, know the truth now. I was at the FBI in 2017 on a food and water strike. And I have a video where you hear me calling for the arrests of every judge of this court. And now I'm having to come to this court for my baby. After I made that call for the arrests of the justices of the United States Supreme Court and of the Fifth Circuit and of the Texas Court of Criminal Appeals and of the Supreme Court and the other lower courts in March of 2017, right during the time when, right before, what I say, 17? So was it January? I'm not sure when it was, but the video date will show, so it had to be in 2016, I guess, where Assistant Special Agent in Charge told me that he asked me to hold off going on the food and water strike. Why don't you say his name? Mark Webster told me, asked me to hold off on going on the food strike. I delivered to him. You will see him just happened to be leaving. He is the second in command of the FBI in Houston, Texas. And that building looks like it could probably hold some 2,000 or 3,000 employees in there. That giant public building under the control of the federal government, an agency, the Federal Bureau of Investigation, an agency of the federal government. But he had told me that the Super Bowl was coming and asked me to hold off on going on the food strike until after the Super Bowl. So I did, and so I think I went on the food strike in March. Yes, March. I just have to look at my dates. And so this was like what, March, April, May. 2 months later, this happened to me and Brandy. 2 months later. So every day it's getting harder and harder. So we're just sitting here waiting on the Fifth Circuit to give us back our baby. And what's the delay? We don't. Why is there a delay? We never. I mean, first of all, Brandon was held kidnapped. No one that is holding you kidnapped can make any claims of child abuse against you. Governor Greg Abbott, on September 1st, 2015, signed a public proclamation vetoing Senate Bill 359, stating his reasons that, he goes and gives him reasons that, I don't have the proclamation before me, but it's on my Facebook page. And he explains that you cannot hold a person against their will without their consent or legal authority. You need a court order to hold someone against their will, even if true, even if that person claims that person wants to kill his or herself or someone else, do harm. The governor, in his proclamation, stated that hospitals have on hand peace officer 24 hours, and all they need to do is pick up the phone and call law enforcement to deal with that. But you, private people, cannot do it. And Brandon's here trying to tell everybody, I never told you that. You asked me if I hear voices? Yes. But did I tell you that I want to hurt myself, kill myself? Did the voices tell me? I did not tell you that. But you want to commit healthcare fraud so that you can get the bounty money. People, this is nothing new for Congress. Congress has had many people in the 1990s to testify that hospitals and others, they kidnap people so that they can get from private hospitals money. They pay them for referrals. So these people, this doctor you see in my video, and the rest of them, they wanted their referral money. This is not their first time doing this. Look at all my videos where they tried to cover it up. As in my videos you see and hear Memorial Hermann Hospital in the Texas Medical Center here in Houston, Texas, saying that she has never been in our facilities and admitted or committed or admitted or received any treatment whatsoever, except one time, which was on May 14, 2017. Other than that, she has never been here. You see all the video. I have a lot of audio too that I just have not taken the time and put it out. There's no need to. The problem is, why is the Fifth Circuit stonewalling? Why? People, even if there had been child abuse, let you understand now how this works. This is not something that only the state of Texas has authority over. It is the federal government. It gets very, very deep. It's so much to explain, so I don't even try to take the time because I've already did that elsewhere. So I've put the protection out there so that no one escapes. No one. So I'm hoping that President Trump has secretly got the Secret Service the military, the National Guards, or whomever watching me and watching them to see if they'll make a move against our lives. I'm so hoping. And it seems to me that they want this impeachment procedure to go forward so they can try to remove Trump and then throw out our case, knowing what I've said I would do. Mr. Trump, I don't know how much longer I can wait. I don't know why. Because I don't know why the Fifth Circuit is stonewalling. It is causing me undue anxiety that these people got my baby. I'm never going to get these days back. These hours, these seconds, these minutes, these years. Secret Service, military, National Guards. Please help now. This is taking too long. My mother was in court the next day. I was in court the next day. The next day that my baby was, the next day after my baby was taken was the first day of the term for the 314 Judicial District Court of Harris County. The judge never showed up. They got a lot of videos on YouTube where judges don't even show up. They go out meeting with their secret girlfriends. They go out play golf, doing anything other than going to court. They'll just go on YouTube and type that in. This judge did not show up. But as I was going on to say, one, Texas recognizes 5 fathers. 5. People, when you look at me this way. When I say that I am the presumed father, think of me as being an adoptive parent. You can understand how a man adopts a child. Can't you see how he would be the legal daddy of the child, although he's not the biological dad? Well, the laws in the United States don't so much recognize a man just because he is the blood daddy of a child. Now, let me get it in here. I am Caden's blood daddy because they got DNA, but from my mother. The reason why I gave them no DNA is that I was not served, which means that the court never acquired jurisdiction over my person. Only after I have been served with a citation and given a copy or a duplicate of a complaint or petition can the court exercise its jurisdiction over me through her judge. My mother was in court. My phone records and the satellite tracks tells you how long it takes me. Just go up there. My phone shows you my phone. I have deliberately my phone tracking me. They think they are dealing with a doggone fool, but they see that they're not. One supervisor, Tanya Johnson, called me. Mr. Whitfield, come on, we're finna hold a hearing. I get there, no hearing was gonna be held. They thought they were dealing with a damn fool, which means that the CPS, they committed crimes here. So, Fifth Circuit judges, are you acting to protect them? Does someone want me to accidentally or intentionally come up dead or murdered or killed so these people can get away with something? I've been calling. I've called. They got me blocked from calling the court. What are we waiting on? CPS cannot get out of this. Judge Phillips, he cannot get out of this. He committed crimes. And so did the federal judge, what's his name? The federal judge in this case. He kept dismissing my wife. He's committing crimes. And I know, God knows the President of the United States got to, because you've seen how President Trump has former prisoners in Congress last year at the State of the Union. I was supporting Trump. My video shows how man, they had a woman at the FBI working for FedEx come by and accuse me of going to get us, meaning black people, sent back to somewhere we never been. Africa after she left the FBI. I was supporting Trump when you all were laughing at him. So, you know, we're going back to 2015. I was on the phone with the FBI when one of the agents that you'll see in a video coming out to the parking lot of the FBI, but in a phone call months later or before, asking me, Ronald, who do you want to see become president? Trump. And little did I know, at some point, the phone disconnected. And I'm just talking, and I look down, and nobody's any longer on the phone. Nobody's on the phone. And I've been trying to state that clearly in the video, but it seems like either video cut off or I do something wrong. I mess up in getting that out there. I got them. They don't have me. I got them. I just know, and my gut feeling is that I'm with all due respect. It's like the Fifth Circuit. My gut feeling, which I don't rely on, is that all the judges of the Fifth Circuit don't even know what's going on. I think only a few judges know about it, and most of them are here in Houston. They know. But those judges that Trump has appointed on the Fifth Circuit, they don't know. So I'm asking you all to call all the circuit judges. I want to call a judge on the Court of Appeals, Federal Circuit in Washington, Sharon Sprout or Proust. She's born on May 24 like I am. And see if she'll help me get all the federal judges in the United States aware of what's going on. So they can call the Fifth Circuit judge, hey, what's going on here? Of course this man is acting this way. You cannot, and why would anybody punish a man and torture a man for standing up for what's right? I'm not finna just let somebody do me in. I don't stand up for myself. I don't know nothing about that. I went into prison standing up for myself. And for so doing, that labeled me crazy. A mentally ill patient for standing up for myself. So what could I do? I couldn't get violent with him because I am non-violent unless you put your hands on me first. And then you will see a monster. I have to be justified. But they labeled me as being crazy. So I couldn't get violent. So what I do, I go on a food and water strike protest. Food and water strike. Started off going on food strikes. I used to call them hunger strikes. But so I told you, Texas recognized them, just going back to so that's how they label me. I'm not crazy. I'm just radical. I've seen a lot. You don't know what I've seen in prison. You don't know what I've seen in what I have seen in federal court by judges, federal judges. So they know why I'm like I am. So I can't show respect to someone who has shown me who they are. They've showed me who they are. And, you know, they got my baby and it's hurting me. I'm tired. Me and Brandon, we're miserable. We are depressed. So when you are depressed, what you do? Sometimes you don't want to bathe. You don't want to wash your face. You don't want to do anything. Some people want to commit suicide. So they want us to be depressed. I'm asking you, Fifth Circuit judges. I'm asking any federal judge. I'm asking you, Mr. President. I'm asking anybody in the Secret Service. I'm asking anybody for help. This is too much, man. How can the world? This is what's angering me, because I'm thinking that God is gonna do something to the United States, because if you know God's mind, it seems that God foreordained and the laws of nature such that somebody's supposed to stand up. And God is probably, because God doesn't know everything, but God knows of all the possibilities of our actions. That's what I mean by free will. It's not that God would be surprised at anything, but God obviously is giving somebody time to say, hey man, enough is enough. That man fought the long fight. He suffered. I've been suffering since 1987. So people, Even, you know, they claim that they are terminating Brandon's right because she tested positive for drugs. Yet her doctor, her personal doctor, her doctors from MHMR, they was testing her too. The doctor has Mark. His name is Mark Williamson. We got her medical records since 2016, 15. Brandon has not tested positive for any drugs. For nothing. Only time she has tested positive is when CPS says she had. But make sure I get it. Make you follow what I'm saying. While someone who has no interest, no dog in his race, who is constantly testing her, and we didn't even know it at the time, and CPS took out her mental health records from MHMR. Dr. Williamson was testing her too. The lab results go to Austin, Texas. Brandon repeatedly coming back negative for all drugs. Yet CPS says she's testing positive for drugs. And so they said that they terminated her because, one, she was testing positive for drugs, and two, she was hanging around the alleged father. Not that she was hanging around her husband, but some stranger, because that's what an alleged father is. As I told you, Texas recognizes 5 types of father. I am both the biological father. They got the DNA from my mother. It's on the record. It's on the docket sheet of the court. The DNA shows that my mother is Caden's grandmother. The DNA established who my son is. But they were, they in court committing a fraud, saying that I'm not, Lord, I need to get it clear to you attorneys. CPS was claiming that I was the alleged father, knowing that not only is my name on my child's birth certificate as his biological father, but also our marriage license. CPS and the judge Phillips would have you, because they assume that y'all stupid, the world. The very fact that Brandon and I were married 79 days before Caden was born makes me his legal dad, regardless about me being his biological dad, because the law don't really recognize that, because you got a lot of men that father children, but they do nothing for them. So that's where we come up with the term parent. A parent, on the other hand, has custody of, cares for, and has management over a child. And that's what I did. You see my videos. I don't post them all out there. Most of them out there. Some of them not. I got cell phones and such at such time, need to go out. I'm at the hospital. I got videos of me at the hospital. But I don't put them out there. Some I do. Many I do. So, I pick and choose what I want to put out there. But what I'm saying, it's taking too long. All the judges that are appointed by President Trump, he put you there to stop the things that's going on. The very thing that we're going through. I'm being attacked. I'm a Donald Trump supporter. I'm an outspoken person. I got them.